Now, President Cyril Ramaphosa's lawyers have accused Public Protector Busisiwe Mkhwebane of making a reckless determination in her findings in the CR17 campaign funding matter. Mkhwebane directly petitioned for leave to appeal a High Court ruling that dismissed her report, which found that the president violated the Executive Ethics Code. She also found that there was a prima facie case for money laundering. Newzroom Africa's senior political reporter Ziyanda Ngcobo has more.
The first task of the day for lawyers representing Public Protector Busisiwe Mkhwebane was to prove exceptional circumstances which warrant the attention of the Constitutional Court.
I suggest that the clash between the head of state in relation to the extent or the standard to which he must be heard and how far the public protector can go to deal with the head of state and the nature of his or her accountability. In our submission in this case, is a matter this court must consider exceptional.
After arguing that Mkhwebane has the jurisdiction to investigate intra-party political campaign funding, proceedings turned to why she conflated the words willful and inadvertent in describing whether the president lied in Parliament.
I do think there is a clumsy way of swapping deliberate and using it with inadvertently and willful. But in my respectful submission, I think although the two words are found in different places, willful and deliberate, my submission is that the substance of it is that they mean the same.
Meanwhile, investigative unit Amapungane wants the Executive Ethics Code to be declared unconstitutional if it remains in its current form.
Our case is not about whether President Ramaphosa breached the code. It's about what the code requires in light of the Executive Ethics Act, read in light of the Constitution, and whether it meets the requirements of the Executive Ethics Act.
But President Cyril Ramaphosa's lawyers argued that the public protector quoted the wrong law in her findings. She is also said to have ignored evidence presented by the Financial Intelligence Center, which told her there was no money laundering in the CR17 campaign funds.
The public protector made two very obvious errors. Frankly, errors so obvious and so patent that no lawyer acting in good faith could have made those errors. And they were, in the first place, that she misread the applicable provision of the code, paragraph 2.3a, misread it badly. And not only misread it, but quoted a variety of renditions of the same provision, which is a symptom of recklessness of an appalling kind.
So when the CR17 campaign raised funds for an election in an ANC NEC, 80 people, not one person as it has been wrongly suggested, it was plainly not performing a public function under legislation. It was plainly not exercising a public power under the Constitution or legislation. It was plainly not using any public funds. And so the only feature that remains to bring this into the rubric of public is the identity of the actor, that the deputy president was one of the 80 actors.
Judgment has been reserved. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Johannesburg.